Human rights activists have welcomed the dismissal of a criminal case against an unnamed 25-year-old man accused of committing aggravated homosexuality. The matter was struck off the court roll on Monday, 2 years after the man was remanded in police custody for the crime, which carries a possibility of a death penalty if found guilty. The East African country enacted the Anti-Homosexuality Act in 2023, defying pressure from Western governments as well as local and international rights groups. For a look at what the accused have gone through in the past 2 years, we are joined now on the line by his lawyer, Douglas Mawadri. A very good evening to you, and thank you so much for speaking to us.
Good evening.
So let's just first start with the court case. Can you just give us a culmination of events that led to the verdict today?
Firstly, thanks for this call. The accused person was arrested. Is the first person to be arrested shortly after the Anti-Homosexuality Act 2023 was enacted. So this is one of the first person who was arrested, and his arrest culminated a number of pressure. First of all, from within the LGBT community to the government of Uganda and other groups to be able to have this act struck off. And ultimately, this individual was arrested, and he has been undergoing trial ever since 2023 until 2024 when he got bail about 350 days after when he was on remand. And so that, in other words, we look at it as a pre-trial detention, which he has already served the sentence for the 350 days. And so upon getting bail, he has been going for his hearing until yesterday when the court actually discontinued his trial.
And what were the reasons for discontinuing the trial?
The reasons were that we made an application to court about whether or not a person who appears to have suffered mental health arising from his long-term detention in prison stand trial. So, of course, by the time the prosecution has presented 5 witnesses, and in the Ugandan criminal trial procedures, it's very difficult to actually strike off or to discontinue a case once when the prosecution starts hearing a case. So the prosecution, by the time, has presented 5 witnesses, and so they could not at any material time actually discontinue this case. However, as defense lawyers, we presented a medical report detailing this person's mental health, psychiatric report about this individual. And we told court that this is an individual who actually has suffered while he was in detention for the 350 days while he was being detained. And so he had developed some mental health condition, which actually the psychiatric evaluation report indicated that he had a little bit of some psychosis, which was resulting from the fact that he had been overly detained at prison. And so because of that, we made our submission to say that this is an individual who is actually not sane anymore to be able to stand this trial. And of course, the penal code provides that every person is presumed sane unless when any other contrary provision, other contrary position has been found. And so the psychiatric report actually indicated this is an individual who has actually suffered a little bit of a mental health, who had developed a little bit of a mental health condition from the long pre-hearing time. So we told court that this is an individual who can actually not stand trial because of his mental health condition. And that was actually our...
Without obviously betraying his identity, could you just give us a little bit more detail about the events leading up to his arrest and his detention, how it has led to a deterioration of his mental health?
From what we gather from his family members, this is a person who actually has been doing some casual labor in a city in eastern Uganda. And so ultimately he got arrested and was detained. And his arrest was actually, there was no complainant in this case. He was actually arrested by a police officer. And so the police officer in this case was the complainant in this particular case. So they brought the victim, which is actually his partner, to actually testify against him. So and so that could actually lead it indicates that his arrest was simply orchestrated by the state itself, because there was no complainant in this particular case. The complainant is actually a police officer. The only thing was that there were other information, for example, medical reports that actually indicated that it may not necessarily even be true, but there was a medical report, but also there was some information that were gathered both from him and also the victim, and ultimately those are the things under which they were being tried upon.
And you say his partner was made to testify against him. Was he threatened to do so? I just want to understand what legal frameworks were used to compel the partner to complain against him. To testify against him if he was not the complainant.
I will strongly feel that the partner was coerced to testify against him, and out of fear that he might be detained. And eventually he was turned to become a state witness. So he actually came to court and testified as a state witness. And mind you, that there was a lot of, at that particular time, there was a lot of intimidation and fear for any other person who could actually be arrested under that offense. And as I said, this was an offense which at the time was politically motivated, and there was a lot of pressure on any other individual who could actually be associated with that particular offense. So we believe that the partner becoming a state witness was out of coercion, but not out of willful intention, really.
And just this outcome, does it have any legal precedent for challenging other long-term detentions under the Anti-Homosexuality Act? Or perhaps even any other legal act?
Yes, absolutely. We looked at it in quite a number of things. First of all, we look at it in a sense that people are being actually forced to give statements at police, and both even at police or even at court, not willfully but out of coercion. But also the other important part of it is that people have been, many of these LGBT community members that have been arrested have been subjected to a lot of torture, both during trial, but also during detention itself. And people are being held in detention for quite a long duration of time. And for this time that people are being held in detention, they are being subjected to a lot of torture, even by even the inmates within the prisons, by prison officers and shame. And so most of the suspects tend to develop some kind of condition, which is, I would like to say mental health condition, but they tend to develop some sense of fear of the state, but also the people around them, and also courts. So we feel that this actually case would kind of set a precedent in respect to trying persons who are unable to understand procedures around them, but also more importantly is people who are being coerced to give statements to police, and also to against their partners against their own volition. So I would like to push for this particular case to indicate that people should at not material time be forced to give statements against their own will, and some of these people actually give these statements at police while they are being coerced, and they are being beaten without any guidance of any lawyers being guiding them in when they're giving these statements. And so we feel that we should advocate for individuals to give statements at police when they are being guided by their advocates where necessary, and if not, such statements should actually be struck off on court records.
Thank you so much for your time, really. Douglas Mawadri is a lawyer of a 25-year-old Ugandan man who was charged with aggravated homosexuality under the Anti-Homosexuality Act in Uganda, whose case has now been dismissed due to mental illness. It brings the time to 19 minutes to 10.
Conversations are happening, and